Evening, everyone, and thanks for watching. I'm Katie Moore.
And I'm Sharice Gibson. A short time ago, we learned the judge who presided over the case involving the recall petition for Mayor Cantrell signed the petition herself.
She did, and according to our partners at NOLA.com, Judge Jennifer Medley signed the recall on December 19th. Then, last week, she signed the settlement over how many signatures were needed to trigger a recall election. A national judicial watchdog group fixed the court, told the Times-Picayune Medley should have recused herself. But some legal experts disagree.
Well, joining us now is WWL-TV political analyst Clancy Dubas. Clancy, your thoughts on this?
Well, I'm also an attorney, and I don't hold myself out as a legal expert, but I don't disagree. I think the judge should have recused herself, or at a minimum, she should have disclosed to the parties, by the way, I signed the recall petition. Does anybody have a problem with that? Judges do that all the time. If two lawyers come before a judge on opposite sides and the judge used to be a law partner of one of them or is close friends with one of them, the judge will typically say, I'm friends with the plaintiff lawyer, I'm friends with the defense lawyer, do you want to ask for a recusal? And the judge will amicably entertain that. But this apparently didn't happen here. And I got to tell you, a week ago, I was on this very set talking about all the ways that this thing could still go sideways, but I didn't have the judge signing the petition on my recall bingo card. Now, here's why this is such a problem. Let's look at the law on this. Judges are bound by the canons of judicial ethics, or the Code of Judicial Conduct. Canon 1, the very first one, says a judge shall uphold the integrity and independence of the judiciary. Basically, the judge is supposed to avoid even the appearance of an impropriety or a bias or a conflict. That didn't happen this time, but there's more. Let's go to Canon 7. A judge or judicial candidate shall refrain from inappropriate political and campaign activity. Is it inappropriate for a judge to sign a recall petition? Well, if you look at the actual petition that was filed by Belden Batiste and Eileen Carter, it's filled out in Batiste's own handwriting, which basically says the mayor's doing a terrible job and she needs to go. So when you put your name on that petition, you're basically saying, I think we need to have an election to get rid of this bad mayor. I'm not saying I said that, I didn't sign it, I can tell you that, but that's what every signer of that petition is saying. Let's go back to that second part of Canon 7, because there's another line there in very first paragraph under Canon 7. It says, a judge or judicial candidate shall not publicly endorse or publicly oppose another candidate for public office. Well, if this recall petition gets enough signatures, Mayor Cantrell is in effect a candidate for office. She's a candidate for retaining her office as mayor in a referendum on whether she should be recalled. And here you have a judge who presided over the case signing that petition, which says she's doing a terrible job and needs to be gone, and we need to throw her out and have an election, and then not disclosing that to the parties when they were in front of her. That doesn't mean I disagree with her rulings. It doesn't mean that I agree with her rulings. The whole point of these canons of judicial conduct are to make sure that the judges and the judiciary as a whole, and judges individually, do everything possible to maintain public confidence in the integrity and impartiality of judges. When a judge signs a petition to throw a candidate out of office or an elected official out of office, and then a matter involving that very petition comes before that judge, how can you assume that the judge is impartial if he or she doesn't even disclose, in this case, that she signed the petition? This is pretty basic.
Really quickly, what does this mean? What's next? What could happen?
The mayor already had grounds potentially to challenge the settlement that was reached. This just adds another serious layer of grounds to just throw it all out and either start over or have started in front of a different judge and start from ground zero on this and maybe reach a different result. Or a court of appeal could say, you know what? We're going to overrule it. Maybe on the law, maybe on recusal. At a minimum, there needs to be more definition on recusals, because there shouldn't be too much interpretation required on this, but if there is, maybe the legislature or the Supreme Court ought to make it clearer. But it seems to me it's pretty clear.
Right. All right. Clancy, I know that this is not the last time that we're going to speak about this.
Oh,
I think
no,
we
there
have a
will
lot
be
more
more
to say. There's a lot more coming, and we'll be standing by for it. Thank you.
Okay.
Well, meanwhile,